Have you ever started what you thought was going to be a simple weekend project? Maybe replacing an old backyard shed. For most of us, that's a quick trip to the hardware store, a little bit of sweat, and you're done. But for one family, that simple project absolutely spiraled into a full-blown legal battle with their homeowners association. Let's break down how this all went down.
I mean, really think about it. You probably don't imagine a little backyard fix-up could possibly land you in court. But for one family, that is exactly what happened. In this explainer, we're going to see how a dispute with their HOA escalated from a simple neighborhood complaint all the way up to an administrative law judge.
So just how quickly can a disagreement about a shed explode? Well, take a look at this timeline. It all kicks off with a simple violation notice in March. Just 5 months later, by August, we're talking lawyers and a formal legal petition being filed. This wasn't a slow burn, folks. This thing spread like wildfire. Okay, let's set the scene. We're in Phoenix, Arizona, in a community called Sundance Ranch. And our story is all about the Negrete family, who had lived in this community for 20 years. They were original homeowners, really proud of their property.
This whole saga really began with a shed they'd built way back in 2005. And here's the key detail. You have to remember this. It had been fully approved by the HOA. But, after 15 years under that hot Arizona sun, that shed was really starting to show its age.
And we're not just talking about a little bit of wear and tear here. The old shed had become a genuine hazard. The structure itself was deteriorating, it was infested with rats and mice, and the final straw? A beehive had moved in right underneath the floor. So you can see why they were pretty eager to get rid of it. So they decided to tear it down and put up a new one. And this is the exact moment where everything starts to go wrong. They made a crucial assumption. Since they were just replacing an already approved shed, they figured, hey, we don't need to get a new approval, right? They even picked a new spot for it, just to make room for a future swimming pool.
And that one little assumption is where all the trouble begins. With the new shed already under construction, the Sundance Ranch HOA gets involved, and what was just a simple backyard project, well, it officially becomes a legal dispute.
It all started with a complaint from a neighbor about the construction going on. The HOA came out to inspect, saw the unapproved shed, and bam! On March 25th, they issued a formal violation notice. Not long after, a second notice arrived, but this time it came with a fine. And get this, the amount was $30. 30. This just proves that the conflict wasn't about money anymore. It had already become a battle over rules and principles.
Now, what's really interesting is how the Negretes responded. They didn't fight it, not at first. In their formal application to the HOA, they actually admitted their mistake. They wrote, "It was an error on our part, not realizing we needed to once again get approval." They explained the whole situation with the hazardous old shed and their plans for a pool, really hoping to just smooth things over. But that honest appeal, it just fell flat. The HOA completely denied their application. And in that denial, a critical new fact came to light. The homeowners were playing by a rulebook that was 15 years out of date. And this right here gets to the absolute heart of the entire conflict. See, the shed they got approved back in 2005 was governed by one set of rules. But in the years since then, the community had adopted entirely new and much, much stricter design guidelines. And the new shed, it had to follow the new rules. And these new requirements were no joke. We're talking a maximum height of just 8 feet, specific concrete roof tiles, and stucco that had to match the house perfectly, and even rules about where you could put it. The Negrete's simple replacement shed, it failed on almost every single count. So with the HOA refusing to budge and the Negretes feeling like nobody was listening, the dispute basically hit a dead end. The only path forward was a formal administrative hearing. And this is where the battle moves from the backyard and right into the courtroom. Now, once they were in court, the Negretes' argument wasn't really about the shed itself anymore, or whether the new rules were fair. Nope, their entire case hinged on a very specific legal procedure. They claimed the HOA broke the law by denying them a final design approval meeting. They pointed to this specific Arizona state law, which says that under certain conditions, an HOA must hold this type of meeting. It seemed to guarantee homeowners the chance to show up and make their case. And since that meeting never happened, they argued their rights had been violated. But, and this is the huge legal twist, when you actually read the fine print of that law, it's incredibly precise. It only requires that meeting for projects involving the new construction of the main residential structure on a lot.
And that brings us to the one simple question that the entire legal case now rested on. Is a backyard shed a main residential structure?
So the arguments were made, all the evidence was presented, and now it was all up to the judge. They had to interpret that one critical phrase and deliver the final ruling.
Well, the judge's conclusion was swift and it was decisive. The ruling recapped the law that a meeting is required for a main residential structure, and then ended with one simple, powerful sentence. That was not the circumstance in this case.
The judge's logic was really simple. The law applies to a main house, the primary dwelling on a property. It does not apply to an accessory building like a shed. So, since the law didn't apply, the HOA hadn't broken it. Case dismissed.
And just to add a little insult to injury, the Negretes were ordered to pay their own $500 court filing fee. This whole story really boils down to one fascinating question. You have these homeowners who made an honest mistake, and they really did try to make it right, but they ran headfirst into this rigid set of rules that had changed without them even knowing it. It really leaves you wondering, when the rules are the rules, how much does your intent really matter?